SJC-13090, American Family Life Assurance Company of Columbus, v. Dawn Diana Parker, and another.
Okay, Attorney Capodalupo, you're on.
Good morning, Your Honors. I represent Dawn Diana Parker and her two sons, minor children. I assume you are all familiar with Sveen versus Mellon. I want to try to keep my comments as brief as I can. I want to tell you concerning the dissent, Justice Gorsuch exposed the majority, and he caught them in what they were trying to do and what they did. And he wanted to warn them to change their minds, and he wanted to warn the states of our great country. And he warned of automatic default rules with respect to private life insurance contracts, that they're dangerous. And he even pointed out that they themselves admitted that when you apply blind presumptions, injustice will occur. And that's our case today. And
Can I interrupt you for a moment,
yes,
counsel?
yes.
I appreciate Justice Gorsuch's dissent, but it was a dissent. And we're a state Supreme Court, and the United States Supreme Court has already analyzed the Minnesota statute, which is significantly analogous to ours, and said that there's no violation of the contract clause.
That's right, Your Honor. I think the great difference and why you should all rule for the appellant is because of the greatest fact in the case. If you look carefully in the dissent and also the majority, it was clear that there was zero true intent concerning Mr. Sveen. All they had was a joint checking account, and that was it. There was no other evidence, and it didn't meet the clear and convincing standard of the Minnesota law. So in these cases, there seems to be a little exception that if you can't prove what the intent was of the decedent, then it would go to the primary beneficiary. In this case, the intent was absolutely clear. He purchased that policy to protect his widow and his minor boys, and not his estranged sister of 18 years. And the intent is absolutely clear. He kept checking if Dawn was paying the premiums. He did not cash it out, but could have. There was an offer, an acceptance, and a consideration. He said he was worth much more dead than alive. There was absolutely zero. All this evidence was absolutely uncontroverted by the appellee.
Can I slow you down for a second? Because
Yes.
you just made a point about offer and acceptance and consideration. The trial judge doesn't address, because you can still win, right? Even if there is this presumption, which you don't like, you can still win if there is a contractual commitment.
Right.
After that, and to me, that's the tricky issue in the case. Is there such a contractual, but you don't argue that, and the judge doesn't address it.
Well, I was denied 2 oral hearings.
Was
and,
that raised below? Was there an argument made? Because I understand everyone was pro se below.
No.
Were you the lawyer below? Did you raise this issue?
In the Plymouth court.
Okay, so did you raise the issue whether there'd been a contractual commitment?
I didn't really get a chance to. I was denied 2 oral hearings. And,
Well, counsel, can I ask a more pointed question to Justice Kafkers?
sure.
In the complaint, is there some other count by which relief could be in the nature of some kind of constructive or resulting trust, something?
Oh,
that-
absolutely. I put everything
so-
under the sun in that complaint, and it's in the appendix. It is in there, and I put everything.
That's fine. So that gets to Justice Kafker's point. So if we're focusing just on this particular issue about whether or not, it doesn't answer the question of whether or not your client can be vindicated on some other theory, but looking at this particular statutory scheme, are you saying that, I mean, what are you saying? That it's unconstitutional, that it's what's your theory here? Are you just saying that you don't like the result because the legislature passed a law that in your view is unfair to your client?
I think the whole purpose of the law is to make sure that funds are not misdirected. and applying this terrible case that I do believe Sveen is going to be overturned one of these days because of their flagrant violation of the contract clause. I know what it says, but it says any impairment, and also the retroactive application.
Can you hold on a minute, please? I think you missed the fastball down the middle with the question. So if you could just say, are you saying that there was an oral contract
Yes.
that takes priority over the statute because it's within one of the exceptions?
If you're going to apply and
Wait a
actually
minute.
acknowledge,
The answer to that's yes?
what was the question again? Oral
It was-
contract, yes. Yes. If you-
Okay, now hold on. Now let's go to Justice Kafka's question. There's nothing in the summary judgment record that suggests, well, you didn't provide the summary judgment record to us. But I assume there's nothing in the summary judgment record that raises this oral contract about the life insurance.
I can't remember what it says. I'm going to assume that it says it. I can't, I put everything I could think of in there, and I was denied an oral hearing to even discuss it, that was
Well,
twice.
I understand that you were denied an oral hearing and it was a dispositive motion, but does the judge in the summary judgment record have anything that suggests a genuine issue of material fact that there was some sort of an agreement between the ex-husband and ex-wife relative to the life insurance policy?
Absolutely. Absolutely, there was. We made it very clear that they, after the divorce and even before, she agreed to take over the payments. There was an offer, acceptance, and consideration. She performed
And
to the
what
very
piece of
end.
paper, what piece of paper in our record that we have right now says that?
Complaint for one, and I don't have the summary judgment record in front of me.
Neither do we, neither do we, neither do we. Where's the genuine issue of material fact? Is there an affidavit? Is there something that was before the judge that suggests that there was an oral contract?
The statute doesn't say written contract or oral contract that can make an exception. And it's clear from all the facts that we presented through affidavit, through interrogatory, that they did have an agreement to continue the payments. And I think that if the statute, this terrible statute is going to apply, that there's an exception written in there. And also the retroactive application, the statute doesn't say it's going to be applied retroactively. If you assume that Sveen is a constitutional case. What else do I want to say? The case turns on intent. I mean, look at the face of just the insurance policy. He left it, it was for a common disaster that the mother should wind up getting the money. He left it to his wife. And, the thing too, just because you get a divorce, the Sveen case says it's not a gumball machine where it's automatic. There's an inquiry whether there's an intent here. That's the issue in this case. And this is why the appellant should win this case. And this is why this court should find for Dawn Diana Parker, because it's unlike Sveen. It's very clear in Sveen they had that Sveen's intent was totally unknown. It says it sounds like he wanted to give the second wife the money, but it's not clear. It didn't meet the clear and convincing standard. We get tons of evidence in this case about intent. It takes it out of that horrible statute, and all the women's groups didn't even want the darn thing. Stiles versus Stiles was a wonderful case because it was absolutely clear, and this muddy thing is horrible. And look at the injustice it's going to cause in this case.
Counsel, can I ask you a quick question? Is there anywhere in the materials that you presented that show that there was an oral argument? I mean, sorry, an oral contract? Yes.
I mean, gee, is it not a contract in my interrogatory answers and in her her interrogatory answers in her affidavit clearly show that he was extremely concerned that the children get the money in her. And what does it say? I mean, that's uncontroverted. They don't even have one affidavit or any witness or they didn't even take her deposition to counteract it. It's completely uncontroverted that that's simply the way the facts were, that he's worth more dead than alive. And he wanted to make sure that, now who else would he benefit from? Even if he did do that ridiculous thing that to recontact the insurance company and tell the insurance company he wants to remake Dawn the primary beneficiary. Isn't that the stupidest thing you ever heard in your life? Because it's
Counsel,
unnatural.
Counsel, you're not making a closing argument. If we could just go back to the question, because again, you didn't provide us with the summary judgment record. Is what you just referred to by way of affidavit and an interrogatory, did Judge Squires Lee have that in front of her when she was ruling on the summary judgment motion?
Yes.
And your suggestion is that because your client's answer to an interrogatory was that she heard her ex-spouse say he was worth more dead than alive, that she continued to make the life insurance payments, that is enough to establish an oral contract?
No, also, she completed the performance of the premiums.
Yeah, that's what I said.
I don't know if the court accepted the documents from the probate court, but it's unlike Sveen. It's absolutely clear that he knew he had a life insurance.
Well, Counsel, you recognize that the judge did not have the insurance premium payments before her, right?
Well, the evidence was, and it was uncontroverted, that Dawn paid it completely. And the only problem was whether or not the divorce caused her to be dead, caused her to be, and I did put constructive trust in the, is there any evidence?
I just want to ask you, I just want to ask you again so that we know the answer to the question. You're not saying that the judge in the summary judgment motion had documentation of payments of premium. That's why you want to enlarge the record. The judge didn't have that, right?
She had the evidence that a sworn testimony of Dawn that she paid the premium was uncontroverted. And I think Affleck also corroborated that too. The premium was paid. It was all paid. It's just a question in this case of who gets the money.
Counsel, can I ask you a question?
Yes.
Thank you.
This is
The
terrible
question
what's
is,
going on over here. This is really just horrible. It's a horrible law.
I understand that you're frustrated.
We gotta get you to,
Who forgets he leaves $100,000 for somebody?
counsel, we're gonna have to ask you to stop if you can't listen to the questions and then answer them. That's the only way we work here. So I'd ask you to bring your voice down, listen to the question, and then answer it to the best of your ability.
Yes, Your Honor.
Okay. Justice Winland has a question for you.
I said, your client was also the insured under this life insurance policy.
That's right.
That's right. And so as the insured, she would have had an incentive to pay the premiums as well, right?
Absolutely.
In fact, she designated the children as her beneficiaries or the estate directly.
I think the policy just says Dawn Diana Parker is the primary benefit. He was actually talked out of putting the kids down because they were minors and you have to get extra lawyers or something.
Well, we can look at the written document. I guess my last question for you is the following. The document, the actual policy says you cannot change the beneficiaries without a written request made to the company.
But why would he?
Was that made?
The answer is no. And the answer
Okay.
is completely unnecessary. This is a private contract. This is protected by the Constitution. And not only that, I mean, why would anybody do such a thing? This contract was signed in 2010 and it was issued in the next day on January something, 1st or something, 2011. The law was amended in 2000. What are the boys going to say? Our father's a bum because he didn't keep up while he was dying of heart problems.
Counsel, could I ask this question again? Because I think we're all trying to get to the same thing. If you're saying that the statute is unconstitutional, that's a separate thing.
All right.
Are you saying that your client established in the summary judgment record that there's a disputed issue of material fact that she fell into one of the exceptions to this statute applying?
I didn't say those words exactly. Frankly, I brought it up probably during the appeal because when I was looking at the statute, it seems like there's an exception for an oral contract that takes it out. And, the statute does say before, during, or after the divorce, marriage, or whatever, annulment, if there's an oral contract. So, but, what am I going to say? Just,
Okay.
I have a few more things to say. I can stop and let you get your ears back. I'm sorry,
got-
I'm emotional
You've
about
got
this
20
because
seconds, sir.
Yeah.
You have 20 seconds to say, well, 15 now. Anything else?
he bought that policy to protect his widow and his children and not his estranged sister of 18 years. And manifest injustice is, that's what Justice Gorsuch predicted would happen.
Okay, thank you, sir. Thank you very much. We're going to move on to Attorney Hurley.
May it please the court, I represent the mother, who is Ms. Joann Parker. The appellee is the elderly mother of the decedent. The court should be aware of the Superior Court record, and at least part of it can be seen at Record Exhibit pages 5 and 6. The complaint was filed by Aflac, the insurance company, setting forth the chronology. However, the appellant, although she did file an answer to the complaint, and she did file an answer to the mother's cross-claim, did not file any cross-claim or counterclaim at the Superior Court, as may be verified by the record. On June 24th of 2019, the appellant filed her answer and affirmative defenses to the complaint. And then on September 11th, 2019, she filed her answer to the cross-claim of my client, the mother. The relevant statute here has been, which is Chapter 190B, Section 2804, in one form or another, has been adopted by a majority of the states in the union, as we see in the first
Can
footnote.
I target you for a second? Because, I followed the probate judge's thoughtful decision, but then I don't address this issue of contract. And I'm not sure she has to or he has to, but I'm concerned about page 89 in the appendix, where she, in her answer to her interrogatories, which are sworn under the pains and penalties of perjury, and I don't know if this is done properly or not, she makes the following comment that she's paid these premiums. I'm just looking for it. So Sean often joked to me he was worth more dead than alive. During those times when he asked me if I was still making the premium payments, and I assured him I was, it is clear to me that he firmly believes there's nothing more he needed to do to make sure I got the life insurance policy benefits for our children. That was the whole purpose of it, he told me. And then I noticed that she has sworn under the pains and penalties of perjury this point. Is that enough to create a contractual issue that fits within the statutory exception? It may not be, and it may not have been pled properly, but it just seems like it's there. So can you address that point for me?
Yes, Your Honor. I'm not sure that this interrogatory answer was part of the summary judgment record,
Okay, so
but
that,
even if it were, I'll suggest that it would not fit under the statutory exception to the automatic revocation, which does include a contract before or after the divorce.
you can contract afterwards, right? The Supreme Court clearly says that these kind of beneficiary changes are allowed without violating the contract clause. But it also, doesn't it expressly say, I can't remember now, that you can create a contract afterwards that resurrects these things or changes this? In fact, that's standard in probate law, where it's weird that it wasn't addressed, the life insurance policy, but it's, I mean, we see these all the time, right? So I'm just trying to figure out what we do with this sort of unanswered issue.
We know that the parties' separation agreement, which became a judgment, did say that this agreement represents the entire understanding of the parties. No other statements have been relied upon.
Did it say that, or did it say that only as it related to alimony?
It said it as to the entire separation agreement, Your Honor.
So even if that went, and I have no reason to believe that you're reading that incorrectly. So assuming that the separation agreement was the end of the marriage and the agreement as to the separation of assets, isn't it possible under the statute to get around the default rule by entering into a contract, whether written or oral, going back to the prior rule, meaning that the ex-spouse is still the beneficiary for the life insurance? That is, it seems to me that's what, I don't know what to call her, the plaintiff is alleging.
Right, the ex-wife.
Yes. He's saying there was an oral agreement, you know, you're reading the separation agreement, so it must have been after the separation agreement, that I would keep paying the premiums and that I would still be the beneficiary.
The language in section 2804 refers to there being an agreement relative to the, I believe it's property distribution or something to do with the divorce. If I can get the actual statutory language, I think here, we don't know when this agreement was made, and we know that the premiums came to roughly $1,200 a year. If we were to look at what the former wife appellant wants to add to the record, it is, I believe, financial statements. But those financial statements indicate that both were paying for life insurance in amounts that would be well over the actual amounts that we see on the policy. The first page of the agreement has actual quarterly policy amount of $200 and something. And we also see from the initial policy that the decedent was paying approximately $15 a week towards the policy.
Can we,
I'm sorry, go ahead, Justice Lowy.
well, I just want one just pointed question that would really be helpful. Page 89 of the appendix dealing with the answer to the interrogatory, arguably suggesting an oral contract. Was that before the judge at summary judgment or not? I don't know the answer to that question. The summary judgment record isn't before us. Was that interrogatory before the judge?
I'm sorry, I don't know.
So-
However, the appellant was responsible for presenting the record. And the Superior Court judge did specifically say, after referencing that the separation agreement was fully integrated, essentially, that the statements were inadmissible in substance. The very conclusion of the Superior Court's order basically says that the only way to realistically look at the intent is to look at the written document, which is the separation agreement, which is very detailed. It includes their cars, it includes debt. And so there clearly was no obligation for the husband to continue with life insurance.
Yeah, but the acts and resolves in I think 2007 in chapter 43, section 5 of the acts and resolves, talking about the default, says that any rule of construction or presumption provided in this act applies to the governing instrument executed before the effective date. unless there is a clear indication to the contrary intent. So the question is there a clear indication to a contrary intent before Judge, I think it's Squires Lee, because of a answer to an interrogatory that Justice Kafka referenced?
We have, Your Honor, there is no clear intent here. There's no date given. The interrogatory specifically says at that time. It starts off referencing the Aflac life insurance policy. It references the joint financial statements, and then it says at that time and thereafter. So we don't know when these statements were made and what would be the consideration. There are these alleged promises to pay, but it's not an actual contract.
Well, if he discontinues, he has the unilateral right to knock her off, right? So he's in consideration of her not paying. I mean, he keeps her on because she keeps paying. That seems like that's consideration, isn't it?
We have no evidence, Your Honor, that she paid.
Well, so do we know who paid for this policy?
We know they both, in their financial statements, which were not before the Superior Court, they both said that they were making payments.
You're talking about the financial statements that were submitted to the probate court prior to this case. You're talking about the divorce case, right?
Yes, Your Honor.
And by the way, they're pro se at divorce, right? There's no lawyers involved in the actual divorce, right?
That's correct, and they both acknowledged that they each had the right to obtain a lawyer.
Right.
The presumption here is because most divorcing parties don't want a windfall. The tacit assumption is that this money would be going to the children, but it's clear that the appellant would have the money for herself if she were to prevail. The problems.
See here, can I do another? I hate to be difficult, but I'm reading the record because it seems to be changing each time. So look at page 69 of the divorce decree. I take it this is before the judge, right? Or is that? Because in its listing of personal property, it lists retirement plans. This is the court form, personal property, retirement plans. And then they check the box. The husband and wife have already divided between themselves all their personal property, meaning which includes retirement plans, and they are satisfied that the division was fair. What do we make of that?
They divided their cars. They had been separated since 2009, 7 years prior to the divorce. And so there was nothing left to argue about as far as personality.
Well, but this suggests that they've worked out an amicable agreement regarding the retirement plan, doesn't it?
But life insurance is separate and distinct from a
Okay, so,
retirement plan.
oh, you're right. Sorry, I apologize. Okay. Mhm.
It's clear that this statute isn't being applied retroactively in this case because the divorce was in 2016 and the law passed in 2012. As Justice Kagan notes in her decision, in the 8-1 decision, which I'll suggest is not going to be reversed in our lifetimes, it's a very minor burden on the policyholder to switch his or her policy beneficiary. And every time there's a premium, as the decision notes, there's very often a statement about you can go online and what your rights are as far as what you can do. So where there was no obligation and there was no firm evidence of any agreement, the appellant would effectively be eating a hole in the heart of Section 2804 and make the exception greater than the rule itself, because any surviving ex-spouse can make claims about what was said where the decedent isn't there.
Well, counsel, that's not really true because we're at summary judgment. It's not saying that they'll win. It's just whether or not they should be given an opportunity to prove their case. So the question before us was there a material issue of disputed fact that exception would apply, and if that was in front of the motion judge?
The motion judge, I think, correctly concluded that there was no admissible evidence of it. It was in the paragraph above order. Although Diana Parker argues paren without offering any admissible evidence paren that Sean intended that she and the children receive the policy's death benefits, the separation agreement is better evidence of a lack of intent to secure those benefits, and it goes on. So to have a trial in these circumstances would effectively eviscerate 2804. The presumption, we know as a matter of law, the separation agreement was the agreement. Imagine if the wife went to court, the probate court, and said, he promised the life insurance and I found out it expired and now he should be in contempt. There is no binding contract here, even if we believe the allegations of the divorced spouse.
Okay, any other questions? Thank you, counsel.
Thank you.